Chief Justice Kwesi Ininyiboa is calling for the adoption of alternative dispute resolution as a preferred choice in resolving cases. He says the country cannot afford to postpone the total adoption of ADR when it is providing absolute and early resolution of cases to many who use the traditional courts. Speaking at the launch of this year's ADR week in Kumasi, Justice Ininyiboa urged lawyers to enhance their capacities in alternative dispute resolution.
Alternative dispute resolution was instituted in 2005 as an intervention to ease pressure on the regular court system. The ADR Act, Act 789 of 2010, which established ADR, makes it imperative for its adoption regardless of the court, including Ghana's apex court, the Supreme Court.
The Ghana Bar Association Ashanti region, we support it because it is faster, it is cheaper, and it reconciles members who are in conflict.
According to Chief Justice Ininyiboa, ADR since its introduction has absolutely resolved 29,558 cases in the last 15 years. He wants all, especially disputants and their lawyers, and the general public to embrace it. He wants the bar, a major stakeholder of the judiciary system, to help entrench alternative dispute resolution in the courts.
Over the last 1.5 decades, the ADR program has to a large extent performed impressively by helping the judiciary to reduce the load on the courts by 29,558 cases. This is a positive support ADR has offered to the judiciary, without which this load would have been borne by the courts under more stressful conditions. The good news is that this number of cases resolved at ADR are resolved absolutely without resorting to appeals, which also creates another backlog. I take this opportunity to urge the members of the bar, as the major stakeholder of the judiciary, to cooperate with us as we entrench ADR in our adjudication process. My lords, distinguished ladies and gentlemen, Sections 72 and 73 of the Courts Act 1993 at 459, CI 133 and the ADR Act, that is Act 789 2010, makes it imperative that ADR should be adopted regardless of the court, whether at the District Court, Circuit Court, High Court, Court of Appeal, and the Supreme Court. The need to work hard in Ghana to make ADR a preferred choice for disputants and their lawyers is now. We cannot afford to postpone it indefinitely.
Meanwhile, Justice Irene Charity Labi, in charge of ADR, has described ADR as a reliable partner to the traditional justice delivery system. She has been explaining how ADR can be accessed in Ghana.
One may ask, how do I access the ADR? A court, at any stage of the proceedings, can refer a matter to the ADR, and any of the parties can also request for ADR during the trial. With the process being optional, the consent of the parties is sought before the matter is referred. The ADR program has been extended to 131 courts across the nation, with at least 5 mediators assigned to each of these courts. A total of 635 mediators have been trained and assigned to the 131 courts connected to the ADR program.
A humanitarian report read to you